will start in Portuguese and then switch to English, just because we have Spanish speakers, panelists here. So we want you to benefit and understand everything, so we are going to speak in English most of the time. First of all, thank you all for coming. I know it's difficult after party to be here, especially after 2 long days of discussions, very interesting discussions. We are going to talk about what's going on in Latin America. This is the 30th seminar on antitrust, and it's called International Seminar. And it couldn't be more international having you guys here participating on that panel. As you know, Latin America, it's very early. The enforcement, it's very recent in comparison with Europe and the US, even though Carolina was telling me that the Colombia antitrust law has over 50 years, but actually the enforcement is very recent for most of our countries. It's the same here in Brazil, and we usually import a lot from the US and Europe, but we have our differences, and we do things differently. That's why we selected these panelists to talk about what's going on in Latin America, especially Colombia, Uruguay, Argentina, and Chile. First of all, Carolina, thank you for accepting the invitation. Carolina is a partner of Baker McKenzie in Colombia. He was selected as one of the 100 most influential women in antitrust very recently. Nicole, also thank you for accepting the invitation. He's a founding partner of Ferrada Neme law firm in Chile. She was also recognized as one of the 100 leading women in Chile. So I'm here with very strong panelists here. Also, I have Renato Guerrieri. Thank you for accepting the invitation. He's a senior associate at Guerrieri Regules law firm. He co-leads the competition antitrust team. He's also editor to the Uruguayan competition yearbook. And last of all, Santiago, thank you for accepting the invitation. Came from Argentina, partner of the competition department of Marval. He's vice president, vice head of the antitrust section of the City of Buenos Aires Bar Association. I will describe myself, and I ask you to describe yourselves. I'm Alessandro Giacalia, senior associate at Pinheiro Neto. I also co-organize with Flavia Chiquito the podcast on the plenary sessions at CADE. We discuss and revise and comment all the decisions issued by CADE every other week. I'm male, white, short hair. I'm wearing a blue suit, blue tie, and white t-shirt. Thank you all. Thank you all for accepting the invitation. I will start with the obvious topic. We had a keynote speaker, Marcos Pinto, who talked about big techs. And of course, we want to know what's going on in Latin America in relation to digital platforms. So Santiago, please tell us about what's going on in Argentina about this matter.
Thank you, Ale. To describe myself, I'm Santiago del Rio. I'm a partner at Marval in Argentina. I'm a tall, white guy with brown hair who should have more salads and less pão de queijo. I'm wearing a blue suit and a white shirt and no tie. I'm the only one without a tie in the panel, by the way. So what's been going on with digital markets in Argentina? Argentina right now is facing a very strong deregulation process across the board. Our government is trying to eliminate a lot of regulations that were impeding investment or that were quite burdensome on private parties. That means that in the immediate future, we will not be seeing any type of DMA type of regulation in Argentina, because on the contrary, investments are being sought out in order to create further fintech and financial and digital companies in Argentina. Now, there is only one exception to this lack of regulation in Argentina, which is fairly recent, which is the Large Investments Act that was passed by the current government a couple of months ago. If a company wants to invest in certain markets in Argentina and obtain huge tax cuts, they can do so by going into certain markets, among which are the technological ones. They will need to carry out an investment of more than $200 million, and when doing that request in order to get all those tax cuts, benefits, and so forth, the novelty on the antitrust side is that you will have to file a report on a pre-basis. This is the very first ex-ante type of analysis that there would be in Argentina, so as to show that that investment is not going to distort the local market. So that's pretty much the only ex-ante regulation that you may have in Argentina for very specific investments. It's not even a merger control thing, it's more of an FDI, FSR type of review. Now, other than that, there are absolutely no regulations on digital companies in Argentina. That means that the role of the Antitrust Commission will be very important. The Antitrust Commission has recently created a digital task force in order for certain members to specialize because they are seeing that their workload on these matters is increasing. When you take a look at the common pillars of antitrust, both merger control and conducts, on the merger control side, you will see that we have had two very similar reactions to digital transactions. When we're talking about big multi-J, big tech deals that have some sort of Argentine connection, we are not seeing major challenges, and that is because Argentina is a post-closing jurisdiction. So what happens is that by the time this big tech deal gets to be filed in Argentina, maybe DG Comp, maybe FTC, maybe CAGI has imposed remedies that have an impact in Argentina because these are global markets, and as such, there really are no big challenges for the local regulator. Now, as regards local digital transactions, it's interesting to remember that Argentina has several large digital companies. Mercado Libre, Globant, Despegar, those are all companies that were originated in Argentina, and we have myriad of other digital and fintech companies. Now, even though over the last couple of years we have always been hearing some sort of chatter from the commissioners as to, well, this transaction may entail some sort of killer acquisition theory of harm, so far we have seen nothing on that front, and deals have not been challenged on the merger control side ever since the statement of objections figure was created back in 2018. So far on the merger control side, things have been quiet. Now, on the conduct side, things are a bit different. You have some of the traditional investigations against the usual suspects, and I think one of the best cases so as to show that is the currently ongoing Facebook WhatsApp case. That case is interesting because there's two things that make it interesting. The first one is that Facebook WhatsApp was not notified in Argentina because the thresholds were not met, and as such the Commission always wanted to take a look at it but was never able to do so because the thresholds were not met. The investigation that they initiated was the result of the Commission going to a conference in Europe in which they heard other authorities were initiating an investigation on that front. And as such, they decided to have an investigation of their own. So there you have a little bit of the influence of the US and Europe in some of our countries. This investigation was initiated because WhatsApp informed its users that they were changing their terms and conditions and that they would start to share information on a more, let's just say, regular basis with Facebook for digital marketing purposes. The Commission considered that the theory of harm here is that there was an exploitative abuse against the users of WhatsApp who could not opt out of the update, and if they did not accept the update, they would basically be rendered without that service. The Commission sought out an injunction. An injunction was granted so as for WhatsApp and Facebook not to modify their terms and conditions. It's interesting because in the initial drafting of the injunction, it was granted for 180 working days or until the end of the investigation, whichever came first. If you have ever dealt with an Argentine investigation, you know that by day 180, we're still discussing powers of attorney, okay? So this injunction was later extended up to the entirety of the process. Now, that's on the front of the traditional type of digital cases. But one thing that I think differentiates our countries from maybe Europe or the US is that throughout Latin America there has been this huge upsurge of fintech companies. These companies that have aimed at the customer base, which have been, for a very long time, they were left out by the traditional banks, by the traditional entities, which were not given credit, they had no payment solutions, it was very difficult to get a credit card. And so all these local champions started to appear. In Brazil, I understand you have PIX. In Argentina, we had Mercado Pago. So all of these companies, as they started to grow, they started to clash with the traditional ones. And there are three cases in Argentina which I think have been very, very clear on this front, and which show how this conversation between the old and the new has been going on and will continue to go on. The first one is, back in 2016, we had a big case against Prisma. Prisma was the sole exclusive owner of the Visa license in Argentina. That meant if you were a merchant and you wanted to offer a Visa payment solution in your store, you would have to hire Prisma. Prisma was owned by 16 of the most important banks in Argentina. The Commission initiated an investigation against Prisma based on several theories of harm. For example, they say that the interchange rate and the discount rate were abusive. But what's important for this conversation is that they consider that there was some sort of diminishment in the quality of the service being provided on a downstream level to other online payment solutions. Prisma had its own payment solution, but in which it provided unrestricted access, while its downstream competitors were struggling to connect to the Visa network. The investigation lasted for a year, and approximately a year afterwards, the parties submitted a settlement before the Commission in which they offered a staggered divestment of Prisma so as to start selling over the company, and as regards downstream markets, they did include a provision by means of which there would be unrestricted access by downstream competitors to the Visa network. That case, which is just an antitrust case, created a huge regulatory change in Argentina as regards fintech. From that moment on, fintech companies were on equal footing than traditional entities, and as such, there was an increase in their market share and in their acceptance throughout the public. The second case, which is an ongoing case, is the payment facilitators case against credit cards. This is a case that's been going on throughout Latin America. I know that throughout the panel as well. And this is a case in which payment facilitators, which are companies which are very, very popular in Argentina, that help customers carry out cross-border payments so as to pay companies located abroad. They charge clients in pesos. For example, in Argentina, they carry out the transaction and they pay, for example, Netflix abroad. Because of all our currency exchange problems of the last couple of years, which would seem to be ending in short, but because of all those problems, these payment facilitators were absolutely essential in Argentina. Last year, there was a communication by Visa and MasterCard that they were changing the rules as regards cross-border payments, and as such, there would be an increase in the fees for such transactions, and payment facilitators in some cases would be banned from certain areas, such as, for example, Europe. There was a claim that was filed by the FinTech Chamber of Commerce, by PPRO, dLocal, eBanks, all players in the digital ecofield, and in which they claimed that this was basically an exclusionary conduct and that they would be left off the market because there was no way that they could compete with Visa and MasterCard's own offerings. The parties requested an injunction. The injunction was granted. As of today, neither Visa, MasterCard, nor its acquirers can actually change the terms of cross-border payments, and this is an ongoing case. And the final case, and I think this is the mother of all fintech cases in Argentina, is the ever-eternal struggle between Mercado Libre and Mercado Pago. Pretty much everyone in the room knows Mercado Libre. Mercado Libre is Latam's premier marketplace. It has an attached payment solution, which is Mercado Pago, and it was created in Argentina, but now it's known throughout Latin America. Modo, on the other hand, it's quite likely you have never heard of Modo. Modo is a greenfield company that was created by the banks in order to offer payment solutions as well, such as, for example, QR, quick transfers, and so forth. Ever since Modo entered the market, there has been this eternal rivalry between Mercado Libre and Modo on pretty much every single regulatory field that they can find. One of those battlegrounds is the Antitrust Commission. Mercado Libre filed a claim against Modo by means of which it claims that Modo is a cartel among banks in order to try to basically attack or to exclude Mercado Pago. What they're saying is that banks are offering significant discounts by paying through Modo, which are not available through Mercado Pago, and also that even though the banks say that they are open, they're having an open banking approach, Modo is the only app by means of which you can actually access the information from your own account on the app itself, as opposed to Mercado Pago. On the other side, Modo filed a claim against Mercado Libre, saying that Mercado Libre and Mercado Pago were a dominant company, that they were not complying with central bank regulations as regards interchangeability of QRs. Mainly, if you go to the baker, you should have maybe, for example, the Mercado Pago QR, but you could pay with Mercado Pago or with Modo. They're saying that they're not complying with that, and that they're excluding them, of course, from those points of sale, and that Mercado Libre leverages its marketplace position so as to include solely Mercado Pago as the payment solution for the marketplace. So they're saying that even though Mercado Libre is claiming that Modo is trying to exclude them from the market, it is in fact Mercado Libre as the dominant marketplace in Argentina that is forcing Mercado Pago on its own operations through its marketplace. This battle will continue, that's for sure. I think we have just seen the first flashes of war. So in terms of digital markets in Argentina, the four things that you should remember is no ex-ante regulation in the very near future. So far, we have not seen any clear acquisition theories of harm as regards merger control. We do have the usual classical cases on abuse of dominance against big tech, and the digital ecosphere is fraught with fighting, and all companies are trying to kill each other. So there will be more on that for sure in the next couple of years.
That's very interesting. When you said that the antitrust authority changed the sector and the regulation, it was the same here in Brazil. We have the same situation where the antitrust authority decided some cases and pushed the financial sector to change a lot. So it's very interesting to hear you that the same is happening in Argentina. Carolina, I want to hear what's going on in Colombia on that field.
Thank you, Alessandro. Well, bom dia. É prazer, é uma honra estar aqui hoje. Obrigado, IBRAC e Alessandro. Me terem convidado a participar. Isto o máximo que consigo dizer em português. Desculpas. So, thank you for having me. I am a Latin woman. I have brown hair, white, about 1.70 meters tall, and I'm smiling because I'm very happy to be here. Thank you. So a couple of comments. First of all, I will have to disagree with Santiago on the cases that he presented. I'm not totally agreement with him. I will explain why. But in terms of regulation of digital markets, in Colombia we have the Superintendence of Industry and Commerce, which is a very big agency for our standards that try to frame or replicate the FTCs, and we see something similar in Peru within the COPI. This is an agency that has in charge consumer protection, data protection, antitrust, trademark law. So it's a very broad agency authorities that the agency has. In Colombia, the cases with respect to some of the social media cases, particularly the WhatsApp and Facebook and others, the agency focused more on the data protection aspects. And this is very interesting, and we saw it throughout the region, because as opposed to looking at from the antitrust angle, it looked at it from the data protection angle. And I think we're all aware that there is a big convergence between data and antitrust throughout the world. This is something that the agencies are looking for. The antitrust authority is now trying to obtain the regulation on artificial intelligence. There are several bills of law, but the agency has already issued some guidelines on the use of AI. So look for that. It's soon to come. I know Brazil is looking at a very comprehensive AI regulation, but we will probably see that cascading in the region. I know Chile has also a very good bill, Argentina, Mexico, and Peru already has a law with principles. And talking about how we compare or diverge from the European Union, basically, I think the reason why Colombia adopted new regulations in 1992 that are basically framing Articles 81 and 82 of the old regime in Europe. And the reason was that at that time, the authorities were not proficient in English, and the decisions from the European Union came in Spanish as well. So I think that's why there is such a huge influence in the region from the European Union, among other things. But I think it's an explanation on why the authorities were looking at that, and also because of the civil law approach that the EU uses, as opposed to what we see in the US. Having said that, there are issues like advocacy that are being used. And talking about two different markets that I think are relevant to discuss very quickly. One is the open finance. So right now, we just saw some regulation coming from the central bank with respect to low-value payment systems. But there are comments that the antitrust agency, the superintendent, is considering in order to advocate for some further regulation and changes. So the first one is the topics that we have seen are subject to discussion are whether or not the agency will advocate for mandatory participation measures for the main market agents. So the conclusion is that unless everyone is in this market, there will be no traction. And this goes to economies of scale, network effects that can only be materialized through the participation of the most significant agents. And what they're trying to help the low value payments system is that the big banks are trying to say, I'm subject to high regulation, and that has created significant costs. And now we are confronted to actors with low regulatory burdens, and therefore there is a reaction there. So from the antitrust perspective, I think that the challenge that our regulator has is trying to bridge that discussion and make sure that we get traction and hopefully get an all-in so that we can frame the development that we're seeing in Brazil, now in Mexico, and surely in other countries in the region. There are some concerns about, for instance, the use of technologies for discrimination from the big actors. For instance, if they imposed specific technological measures to use the entrance of the big actors, then how will the other companies be able to obtain entrance with that? The other aspect is on the costs of the transaction. So there's advocacy in the sense that consumer-to-consumer transactions should absolutely have no cost, but there's also some advocacy with respect to the regulation on the prices between inter-institutional costs. So the big actors cannot use pricing to foreclose the entrance of the smaller actors. So we'll see what happens. This is right now with the antitrust regulator, but it surely will be an outcome that we will see developing more and more. The other market that is interesting is the transportation platforms industry, and right now there is a big investigation from the SIC pending. I think that there have been a lot of pressures from the taxi companies to try to hold that this was that the platforms are operating under unfair competition terms. The advocacy and the arguments from the platforms is that this is a different market and that they offer different type of services that the taxi drivers are not offering. I read the report from CADE with respect to what happened here in Brazil, and something that was really appealing to me was that at the beginning, the taxi drivers had a decrease in their demand, but after some maturation or maturity of the performance of the market, they started to gain traction again. I think there were some measures that CADE and the regulator adopted, and I think that is a very good lesson to learn, in the sense that regulation helped the taxi drivers, so far as I understood it, to obtain traction again, and their market shares and the participation increase again. So that is the discussion that we're seeing in Colombia. I will not litigate with Santiago, but I will say
if we can charge it, we can do it. I mean, we should share the matter number with everyone. We can do it here.
I came here on academic purposes, Santiago, only that.
We have something to say too.
But I think that the position of the other side is that disclosure information and transparency to consumers is very important. And we have some case law and some doctrine in Colombia with respect to the harm that non-disclosure of information for consumers through the payment facilitators is causing certain harm. Not to litigate. Well, thank you very much.
Thank you, Carolina. Yeah, when we were discussing the topics that we would cover here in this panel, one of the topics that Carolina brought to the discussion was down rates, which was something very interesting for me, actually, and for the Brazilian practitioners, because we saw a decrease of the number of down rates here in Brazil. Last year, the CADE's annual report mentioned that there were only 2 down rates that were conducted here in Brazil last year. But as we know, down rates is a hot topic in other countries nearby our neighborhoods. And this is an important tool not only to investigate, but also to punish cartel and other anti-competitive practices. So Carolina, I want to hear about what's going on about down rates in Colombia.
Thank you, Alessandro. If I may, I will refer a little bit about a study that Baker McKenzie performed with respect down rates worldwide post-pandemic. And I'm very happy to share with whomever wants to ask for this. It's a map that we have in which we show that in Europe and in the US, but also in the East, we saw a big increase in down rates post-pandemic. So I think that is a very important point, because I agree, we were seeing a reduction also in Colombia. Colombia in 2018 had about 100 down rates per year. So that was a really shocking figure. Now we don't have as many, but with the new superintendents, this new administration, down rates have continued to pick up. So we saw that, France, Spain, Ireland, the US, UK, Turkey, Romania, South Korea, Singapore, Philippines, Bulgaria, Japan, Netherlands, all of these countries sort of exploded. So what we tend to say among our team is that this is an old tool, but with new risks, and I will explain why. So first of all, we are seeing more and more coordinated approach between regulators. They are talking more and more with each other. But of course, technology is not only for companies. Authorities are also using technologies to supervise the markets and also are using e-forensic or e-discovery tools to undertake this type of investigations. So opening to new models. So what we're seeing now is that with a hybrid way of working, the authorities realized that some companies were keeping information that they didn't have access to at the homes of the employees of the companies. So in Europe particularly, the authorities are starting to go to the residence of the employees, which is quite frightening. So the other issue is, despite coordination between the agencies, what we are seeing is that, of course, the regulations are not the same. So the approach that the authorities take for the same case in different countries do not necessarily apply the same standard. To give you an idea, and this is something that I often have to explain to my clients abroad, is that in Colombia, for instance, the SIC, which is the antitrust regulator, does not need a judicial warrant to perform done rates. And that is quite shocking, and I can see Nicole's face like surprised. And that is really not easy to digest. This situation was subject to testing by the by the Constitutional Court about 5 years ago. And we all had the expectations that the court would sort of modulate this. It did not. It only confirmed that the agency had all these faculties. It sort of said that the SIC does have to explain what's the market and exactly what it is looking for, but it does not need to convince any judge of the faculties, so it can do so very, very quickly, which is somehow why in 2018 we saw so many done rates. And I think it's going to pick up again. In Colombia, surprisingly enough, the SIC done rated the Ministry of Foreign Affairs about 6 months ago. So it was the government rating the government, which would cause a lot of noise with respect to an allegation on passport, on the passport issuance and a contract for passport issuance. And there were allegations of bid rigging and influence or adverse influence of contract awarding. So the approach is not the same, but the new tools, technology, and the ability to go into the houses of the officer is coming, and I think we will see it in Latin America more and more. With respect to that, I'm not sure if the SIC will have the ability to go to the houses without a judicial warrant, and I think that's something that will be subject to big debate in Colombia. During the pandemic, we had virtual done rates, and this was quite scary because what the SIC did was that it would summon you to a Zoom or a Google Meets or any other platform, Teams meeting, and once you were in front of your screen, the authority would ask for access through the technological platform to the files in your computer. Everyone was shocked. So we were living in a pandemic, we were already living in very extreme situation, and the authority was wanting to access your house through the platform. That was very, very shocking, and I remember that the only way we managed to persuade the authority in a couple of situations was for cybersecurity implications. So we said, we cannot do it because of cybersecurity implications. You need to explain to us what are your technological protocols, and because you would not only be accessing my computer, many of these would go directly to the cloud. So that triggered a lot of specific issues. Something additional that the done rates trigger is the need for companies in that regard to have protocols on document retention. So document retention has always been there, the protocols have always been there, but are now more and more important in the sense that cloud services and the way that companies are keeping files has evolved. So the companies should think about this, and in that regard, the cybersecurity issues should also be anticipated. Talking about anticipation, I think we've all discussed with our clients and within our companies about receptionists or reception teams being forgotten in the training of done rates. And often this comes as a surprise because they are the first face that the regulator sees. And to talk a little bit about some additional statistics, we are seeing large fines for obstruction in antitrust rates throughout the world. One country that is really pioneering this is Poland, where we are seeing fines of up to 30 million euros for delaying the starting of the inspection. So not having a proper training for the reception person or not having a consistent approach will probably trigger the regulator exploding the fines. Another case which is quite interesting is that in Turkey, a company was subject to the 0.5% of the previous year turnover, so the fine was that high, for refusing remote access to former employees' data. So they had that in the cloud, but they were holding that there were data protection implications and that the authority did not have the ability, and they were charged for obstruction of done rates. And so on and so forth. In Colombia, very quickly, personal mobile devices. So there was a done rate in which the manager of a company refused to hand over his personal device, holding that that was not part of the company's tools. The authority asked if this gentleman would communicate, even through WhatsApp or other platforms, with the employees of the company. So he said yes. And the authority said, well, then that is a work tool that you need to hand over to me. He refused, holding that this was not the company's and that they didn't have the ability to do so. The tribunal confirmed the fine from the SIC, and this gentleman received a very significant fine in the vicinity of $100,000 for refusing to hand over his phone. So again, training and awareness of these new risks is quite material. Two more topics. The destruction of evidence, and unfortunately, this is something that you don't think that would still happen, and it's happening. I know of a case where companies panicked, and some employees actually put their computers within the microwave oven to destruct the computer. I think training employees to let them know that the information is no longer in the hard disk, but it's in the cloud services, it's very important. But in addition to that, this type of activities or this type of intentions can create very huge implications. In Colombia, that caused a fine of $5 million. So that was very significant. And then finally, of course, it's the implications with respect to data protection. The authority has broad authorities to investigate. The authority does not need consent. And we know that Brazil has the Ley General de Protección de Datos. Now Chile is adopting a more GDPR approach. We know that there are certain bills of law in Argentina, but you're not there yet. And we know that Colombia is considering. But most of the countries in the Spanish-speaking Latin America, we have the old frame of Europe, and that is based on consent. And so the authorities will come, they will take the data, and after, when the company needs to do the internal investigation, they sometimes face the situation that they don't have all the information or they don't have access to the information because the employees are claiming data protection rights. So having a policy, understanding what type of information can circulate through personal tools, and understanding what type of consent the company has is critical. So I think that's about what I was going to say. I think my time is over.
Thank you. Thank you so much. And Nicole, I understand that the down rates issue is also a hot topic in Chile. So if you could elaborate on that, that would be great.
Thank you very much, Alessandro. It's my pleasure being here. I'm Nicole Neme. I am a partner at Ferrada Neme Law Firm in Santiago, Chile. I am also a professor of economic law at Universidad de Chile Law School. So I greatly appreciate this invitation. And Alessandro, thank you for all your effort in putting together this international panel in the nicest possible way. So I am a woman. I have clear skin, brown hair. I enjoy also smiling as Carolina. And today I'm dressed in shades of brown and black. Yeah, as Alessandro said, down rates are a hot topic in Chile also. And let me start by reminding us a little bit of some of the relevant features of the Chilean antitrust institutional design. It's not working?
No,
okay.
Just close.
Thank you. It's thank you. Common issue because of my size. Okay, so we have this antitrust institutional design created in 1973. So our antitrust law is pretty old for Latam, considering other Latam experiences. But this law was entirely amended in 2004. And from that date on, we have a twofold system with two bodies, different bodies. So on one hand, we have the Fiscalía Nacional Económica, FNE, which is the independent agency in charge of investigating potential breaches to antitrust law, including cartels for sure. And on the other hand, we have something peculiar, particular. We have a tribunal, a specialized tribunal, a jurisdictional body, Tribunal de Defensa de la Libre Competencia, TDLC, which is in charge of adjudicating the complaints on cartel cases too, and also deciding non-contentious cases. And the decisions by the tribunal are reviewed by the Supreme Court. So regarding down rates, from 2009, the law was amended in order to improve prosecution by the FNE and in order also to better ensure enforcement. And from that date on, down rates and leniency programs have been key mechanism to enhance prosecution of cartels. We have, I would say, a huge experience regarding down rates. In that case, the FNE performs the down rates with police assistance and needs two authorizations, I mean, instead of one, instead of no one, as in Colombia, one from the tribunal itself, from the Tribunal de la Competencia, and the other one from a court of appeal. So Chile is very protective of the rights normally of economic agents. We're a free economic market, so laws tend to protect a lot economic agencies. We have notable cases as like the famous poultry case, the tissue paper, the cash transportation case, the casinos one, the pharmaceutical, where the evidence gathered through down rates was essential. I would say in Chile today, in cartel cases, WhatsApp are like the star evidence the authority uses. So we always tell the clients in the compliance and training programs that don't think that WhatsApp is really, you know, a secure means. It's not, no, there are no secure means. In fact, we had this case where a pen drive was encrypted and the Fiscalía sent it to the FBI to get it unlocked. So they really get to the information that is seized during the down rates. So What are the hot topics in Chile regarding down rates? I would say they are more procedural because, as in Colombia, we have this problem that the law is inspired, the procedural regulation is inspired in the civil law. So the procedure is more a civil procedure, which is not very consistent with the fact that we have criminal sanctions in Chile for cartels. So there are a lot of procedural discussions in this regard. One of them is the access to the file of the FNE. So the FNE seizes, the computers, the personal devices, the documents, and then submits the complaint, the accusation to the tribunal. And the parties involved typically request access to this file before responding to the charges, because they want to have all the information before responding to the charges. However, the FNE has been very insistent and has maintained that they are allowed to present the file only during the evidentiary phase of the trial, which makes the party in a difficult position to answer to the charges without knowing this, bad information included in the file. The tribunal until now has supported that view, which led even to constitutional debates before the constitutional tribunal, but in the future we'll discuss if there will be changes in this regard, but by until now this is the position the FNE has supported and the tribunal too. The second aspect is the confidential information in the filing. So protecting this confidential information is very relevant. Typically during down raids, the FNE gets sensitive information, like on prices, list of clients, projects, investments, etc. So the parties tend to request protection of the confidential information, and the tribunal basically balanced the rights of the FNE and of the parties, issued an administrative regulation, and now it's clear that there is a mechanism to ensure the protection of sensitive data related to the parties involved, which is for sure crucial for maintaining the due process of law. And the third, I would say, key aspect under discussion is the possibility to submit leniency applications after a down raid is performed, which is not really common in every jurisdiction, but in Chile it was accepted, it has been accepted until now. In fact, in the typical very relevant cases, the tissue paper, the pharmaceuticals, and casino, the FNE accepted that the leniency application was submitted after the down raids were performed. So this is something where Chile diverged a little bit from other jurisdictions. There is a discussion from an academic perspective on the pros and cons of that approach, so it's also something that could be subject to further discussion in the future.
Very, very interesting. Now we're going to change topics for another non-obvious topic for Brazilians, at least. I would say that we will discuss now public bodies and national champions. I would say that about 10 years ago would be a hot topic here in Brazil. I checked the case law here in Brazil, and the last decision that mentioned national champions was issued in 2022. And it was a decision in a merger filing, and I will quote the vote of the commissioner. The role of this tribunal is to preserve competition. It is not in CADE's role choosing national champions. But I understand that this is an issue in Chile, and this is something that is under discussion in Chile right now. Nicole, if you could elaborate on that, I would be happy.
Thanks, Alessandro. I might precise a little bit the point. I think that Chile is not so different from Brazil regarding national champions. In fact, we have, prosecution on national champions and other companies is pretty the same. I would say that it's even harsher on national champions. Latam is a good example. Could be considered like our national champion, and they have been subject to many, many antitrust cases, which is, on the other hand, different in the Chilean cases compared to other jurisdictions, and this is why I wanted to bring this subject here today, is the fact that based on our case law, because this is an interpretation by the tribunal and the Supreme Court, public bodies, like public agencies, are subject to antitrust law. So it's not like, I'm not talking about state companies, because state companies are also, as national champions, subject to exactly the same regulation. In fact, this is a constitutional principle we have of non-discrimination between private and public companies. Here I'm talking about public body when they are conducting or exercising public functions. And in this sector, what the case law in Chile has established is that decisions by sector-specific agencies are subject to antitrust scrutiny, which is pretty, singular or particular compared to other jurisdictions. So the point behind this discussion is that administrative decisions issued by public agencies when they are acting within their powers can have competitive impacts on markets. That's clear. For example, administrative actions may create barriers to entry or expansion or exit. They can misallocate essential resources, incentivize collusion, or facilitate abuse of dominant position. And we have precedents on discussing if these particular administrative acts can be contrary to antitrust, and in that case, if the state bodies can be held responsible for the administrative act they issued. Ruling 105, issued by the tribunal, when I'm mentioning the tribunal, this is always the antitrust tribunal, the Tribunal de Defensa de la Competencia, addresses that concept, saying that regarding acts of authority, when actions aim to achieve specific public policy objectives by, for instance, allocating resources, granting rights, or imposing charges that impact market competition, these particular actions can be reviewed and analyzed by the tribunal to assess whether these competition restrictions derived from these actions are contrary to antitrust in Chile. So, Chilean case law basically mandates that regulators must act in compliance with antitrust law when they execute their powers, and they should favor pro-competitive alternative whenever possible. And what is interesting, and Renato was asking the other day if it was the case, and the answer is yes, that violation of the Antitrust Act may entail antitrust responsibility, even fines, for the agencies involved. So this is the discussion I wanted to bring, and it's important to analyze it as, I would say, as a picture and not as a still image, because there is an evolution that is interesting to understand, and comes from an interesting dialogue between the tribunal and the Supreme Court. So I'm mentioning this evolution very shortly. There was a first stage between 2004 and 2009 where there was an extensive interpretation created by the tribunal, meaning that sectoral obligations to sectoral agency had to comply with antitrust law in broad terms. So what the tribunal said is that the court had jurisdiction over action by the authorities, even though they were carried out within their legal attributions. And this was rooted in the fact that antitrust law is considered like a public order law, and that competition law is a part of the principle of legality that is imposed by our Constitution on all state bodies. So at that, in this first stage, the rule was very straightforward, I would say, and without nuances. From 2009 to the present, on the contrary, the Supreme Court has intervened in different landmark cases and had put some limitations to this view, including some nuances and limits on this view the tribunal had that, no, in every case and regarding any power, the public agencies were subject to antitrust. And I'm going to mention very shortly these three landmark cases and their importance, because I think they could be applied to other jurisdictions, or at least the discussion. One of them is regarding to regulated powers. So the Aeronautical Agency of Chile used an upfront payment as the sole criterion to adjudicate or award air traffic rights. And when it did so, for sure, it favored incumbents over new entrants. So the tribunal imposed, considered it was anti-competitive, and imposed alternative pro-competitive conditions and ordered this agency to modify the bidding rules. The Supreme Court reversed the decision, arguing that this aeronautical agency was acting under specific regulated power. So its own sectoral rules obliged the agency to act the way it acted, and the tribunal was not in a position to force the agency to act against its own specific sectoral rule. So from that day on, the tribunal took this precedent, respected it, and the tribunal has been argued after that case that they are not entitled anymore to order the modification of administrative act when they have been issued in the exercise of regulated power. The tribunal now limits itself to making regulatory recommendations. So when they analyze that a law is potentially against antitrust, they recommend modifying the law, but it's more like applying advisory or recommendation power and not obliging the body to modify its administrative act. So this is one of the limits the Supreme Court put. The second one, which is more difficult to apply, is regarding discretionary power this time. So we're not talking about regulated power. It's when the public body conducts discretionary powers. We had this case where two ministries, the Public Work Ministry and the Transportation one, designed a bidding process that favored vertical integration and then favored abuse of dominant position by a company. And the tribunal considered that this was in violation of antitrust law, and the ministries were held responsible, which is, a very strong precedent, that ministries are held responsible for violating antitrust law. And the tribunal said, we're not talking about regulated power here, you should have acted in a consistent manner with the antitrust law. When the Supreme Court reviewed the case, it reverses the decision again, but in that case, not arguing that the powers were regulated, but arguing that the tribunal should have better balanced the goals under discussion. So that the tribunal should have better balanced competition and the sectoral goals that were transportation, efficiency, and connectivity in rural areas. So after that precedent, the tribunal has this hard task of, in every case that a discussion is brought regarding discretionary powers, the tribunal has to balance compliance with antitrust law and proportionality of the sectoral restrictions. And basically, the tribunal imposes sanctions to an agency when two conditions are met. So one, there is harm to competition in the decision they issued, and two, there is disproportion in the measures in relation to the sectoral purposes. So it's a qualitative analysis the tribunal must perform to balance these views. Just to summarize, I think the time my time is finishing. This has been applied in different cases by the FNE, the 5G spectrum case, the duty-free airport concessions, and other cases. And despite these landmark cases and their repercussions, what is important is that there remains significant scope for the tribunal to oversight state administration actions, including the imposition of fines on public bodies. So in conclusion, this dialogue between the TDLC and the Supreme Court has forged an interesting jurisprudence on the interaction between regulation and antitrust in Chile. And this evolving area of litigation, because there are a lot of litigation around these discussions in Chile, sets Chile apart from other jurisdictions, particularly Europe and the United States, where the application of competition law to sector-specific agencies is very limited. So it's interesting to closely follow the trends in this area.
Nicole, thank you. If I could summarize the topic that you described in one word, it would be wow. It's incredible to see the discussion on whether an agency could be antitrust liable. This is very interesting. And Renato, could you answer this question? Are public entities liable for antitrust practice? I want to hear about your perspective.
Bom dia a todos, eu sou o Renato Guerrieri, eu sou associado senior, não junior, no escritório Guerrieri e Regules, em Uruguai. Eu sou homem de pele branca, dos cabelos escuros. Eu estou vestindo termo azul, camisa branca, a gravata laranja. Eu gostaria rapidamente de agradecer a Alessandro pela moderação, a Daniel e a José Rubens pela proposta, a IBRAC. Sempre um prazer para mim participar no seminário, que é o evento Antitruste e concorrência o maior evento da América Latina, mais importante não somente no Brasil. Switching to English now, it's easier for everybody. And in answer to this question, it's not that clear. Just to give some context, in Uruguay, studies have shown that, for example, public procurement is a key factor in the economy, with the state being the acquirer of 15% of all goods, products, and services in the country. And therefore, not only, well, it's of course an acquirer, but aside from that, there are multiple public companies acting and competing fiercely in the countries. Many have dominant positions, some even have legal monopolies in their favor. So it is a relevant agent in the economy, the Uruguayan state. And accordingly and theoretically, the antitrust law explicitly envisages that its provisions, including enforcement for conduct, are applicable indistinctly to both private and public bodies. However, it's not that clear in practice that this occurs. We don't have a record of penalties ever imposed to any public body in Uruguay other than really symbolic, non-binding recommendations. And in fact, there has been a huge doctrine and scholars discussion of whether the antitrust authority would be entitled, even though the law envisaged that possibility of applying sanctions to other public bodies. And we have a super recent and interesting case on abuse of dominance that illustrates these problems in practice, in which, in this case, we represented a leading pharmaceutical company, Roche. And the case, it's about a public entity, which is Fondo Nacional de Recursos, is the leading and quasi-monopsonic acquirer of high-cost medications in the country, acquiring 95% of all products in the market. And they had seen an interesting example of what it's called the Netflix funding model, which is a subscription-based agreement for high-cost medication in Australia that was really working well in terms of budget predictability. And they were the ones, this public body, approaching Roche and asking them to enter into this agreement. Roche accepted, and the agreement was a bundling of 5 different medications, all of which were protected by patents in favor of Roche. Immediately afterwards, a competitor to Roche, another leading laboratory, registered in Uruguay a biosimilar medication and tried to sell it. So we had a renegotiation clause which was triggered, and the public entity asked both parties to place bids. And in case of Roche, they asked, okay, present this bid, bundle it again, another one fully open for all the products, another one, a mixed one where there was a bundle for all the patented products and open price for, and a separate price for the product subject to competition. They review both offers. They, as public entity, unilaterally awarded the contract again to Roche. Yet, the competitor filed a complaint before the antitrust authority on the grounds of abuse of dominance, barriers to entry, etc., etc. And even though the Fondo Nacional de Recursos appeared before the antitrust authority, admitting they had proposed this business model, defending its validity, defending its efficiencies, Roche was the one that got $1 million fine, which fortunately we just got revoked by the administrative litigation court in Uruguay, while the public body just got away with, again, a non-binding recommendation with no monitoring whatsoever. And even if they got that recommendation, they continue with that business model with other minor laboratories. So in the end, there's not a legal issue on whether antitrust is applicable to public bodies, but there's a more cultural, let's say, issue in that.
Very, very interesting. Let's change topic to the last topic that we agreed to discuss today. It's about merger control review. We have seen a more stricter views of the authorities. For instance, here in Brazil, only this year we had 2 cases blocked and 2 approved with remedies, and we expect more to come. And I understand that in Uruguay is the same.
Yeah. Well, in relation to merger control and specifically in relation to multi-jurisdictional deals, small and emerging jurisdictions, like most Latin American ones, have long been considered as exotic ones, whether either there was no pre-merger control proceedings in place, or otherwise this could be easily bypassed on the grounds of notifications instead of clearance, no remedies, no blocking authorities, low risk of visibility, low risk of detention, low fines, sometimes even late filings instead of fines, lack of suspensive effects on closing, lack of proactive enforcement, ex officio, etc., etc. However, this has changed rapidly and noticeably in many jurisdictions, which, as you say, the merger control has become stricter. Addressing Uruguay specifically, as my jurisdiction, we did have the antitrust law in 2007. It was enacted. In 2009, the antitrust authority was established. After that, we witnessed a decade of merely notification proceedings, which was a joke, really, because there was no consequences if you did not file. But that changed after, as in other Latin American jurisdictions, the UN came, they interviewed many of us, of the practitioners, and UNCTAD issued its peer review report diagnosing the jurisdiction and proposing certain legislative amendments. That was the antitrust law was amended accordingly in 2019, and the full pre-merger control entered into force in the country, which is triggered broadly, similar to the European Union, as per any act of concentration where there's a transfer and change in the structure of control of an economic entity. We have some tricky, which is good business for lawyers, we have some tricky turnover thresholds, which refer to both group level of all parties, but also there are individual thresholds. In the end, any big or relevant company with more than 75 million US dollars of turnover at group level in Uruguay gets caught in pre-merger control in the country. We do have, similar to bigger and more advanced jurisdictions, we have notification forms for smaller transaction, and which also take less time, 1 to 3 months approximately. We have the phase 1 for easier transaction. We have simplified forms for cases where there are no market overlaps, etc. And in the end, many proceedings are authorized speedily and with no issues, mostly in phase 1, but phase 2 can take up to 8 months, which is an issue. In practice, we witness a boom in pre-merger control proceedings with up to 70 filings a year. We're a country of 3 million people, so you can see that that's quite something, where we have our hands full with pre-merger control. And even though, as I said, most authorizations have been easy, the authority has legal powers as to impose any sort of remedies, as to block transactions. We've seen some interesting cases. First of all, in terms of remedy, perhaps the most common ones are behavioral, which usually are periodical information requests or certain pricing or capacity commitments, usually the sort of remedies you get in airline mergers, for example. But other than that, we did have a very recent and still open and confidential case where structural remedies were unsuccessfully negotiated. There was a proposal for disinvestment that we did for a client, and the answer of the authority was that it was proposed too late in the proceedings, so under a more procedural argument, they failed to accept it, which was quite controversial. And perhaps most interestingly, we had a record of 4 blocked operations, 2 this year. Just to be brief about it, the first one, not exactly a blocking, but a submission that had to be withdrawn, was in 2020. It was a high-profile merger in the supermarket industry between the 2 largest chains, one controlled by Goldman Sachs and the other by Colombian Almacenes Éxito and French Casino, which perhaps was the first significant case in Uruguay, and the discussion was, oh, these companies are too big to merge. There was a lot of public scrutiny. There were a few complaints by competitors, and in the end, after a really bad initial assessment by the authority, because of the creation of a monopoly in relation to one of the geographical relevant markets, well, the submission was withdrawn. 2 years later, one of the supermarkets had the first explicit blocking in Uruguay on the ground, and this is the typical thing that also occurs in other jurisdictions on the grounds of too much concentration. The HHIs were sky high, way beyond 5,000. And now this year we have the 2 biggest cases ever. One that perhaps you're most familiar with is the Minerva and Marfrigi case, in which we represent, at the firm we represent Minerva. As you know, there was a judgment by CADE recently in Uruguay. The transaction was controversially blocked by the authority in a context also of election year, and all the pressure even for 2 former presidents saying the deal cannot go through in press. And the thing is that many actors from the rural sector are against the transaction, and the current government needs the support from that sector as well. So it was blocked, and we filed for administrative remedies also with the support from Compass Lexcon, and we are trying to revert that decision before the executive branch. That's one case, and the other is the Bimbo acquisition of Magnifique in the bread industry. Of course, Bimbo is more accustomed to this sort of more challenging cases. The transaction was initially blocked in the final decision by the antitrust authority on the grounds of risk of abuse and unilateral effects. But after remedies, for the first time, the authority was super open to reassess the market definition, which were the participants in that market, and therefore the market shares. So in the end, using the DOJ guidelines and also the European guidelines, they reassess and authorize the transaction subject to undisclosed behavioral remedies, which was a very interesting negotiation as well. Other than this, and just to sum up, we have some strange recent case because we do have potential sanctions in place for any infringement to pre-merger control. And this includes declaring a transaction null and void, which in Uruguay, which is quite something, especially for foreign deals. But the authority has shown to be more flexible, and in one case they order us to re-grant a contract, signing a contract again. The parties accepted, and we just ratified the previous contract in a very brief 2-pager one, which was okay because it was a local transaction. The problem would be if it was a foreign, what to do with that. And just to close my comments, the key challenge in these sort of emerging jurisdictions are mostly 2. One is the insufficient regulatory provisions and guidelines in comparison to the US and Europe. We do use their guidelines and also Brazilian experience in the field, but these are non-binding, and that leads to a lack of key definitions, unpredictability and uncertainty, mostly in sophisticated cases. And the other challenge, it's a typical one of insufficient budget allocation and staffing for the authority. They're full, they have an immense case law and strict legal time frame, and that leads for them to to pass simple transactions to phase 2, to ask for follow-up requests for information, sometimes absurdly or randomly, and to focus exclusively on pre-merger control and not having enough time for conduct investigations. So in the end, that delays the closing of many, even multi-jurisdictional deals. So that's the thing in Uruguay.
Thank you, Renato. And here in Brazil, we issued the guidelines on vertical mergers. We have new theories of harm. We have an interesting case decided by CADE involving antitrust and anti-dumping issues. And what about Argentina?
First of all, thank of everyone that has just showed up for the last question. Thank you for the increased attendance. So 3 minutes because we're running very short on time. I wanted to focus on remedies because I wanted to follow up on what Renato is saying. Before 2018, Argentina was an absolute disaster regarding remedy negotiations. But why is that? We're a post-closing jurisdiction. Deals took 3, 4, 5 years to get clear on a post-closing basis. Just imagine during the M&A archaeology so as to divest a deal 5 years after closing. That led to the Commission not doing any remedies at all. And in those cases in which you actually had to negotiate a remedy, it was an absolute nightmare. There were no guidelines. So a commissioner would tell you, I need you to divest this product line or that business. You would do so. You would show up at the Commission saying, I have complied with this. And then the commissioner would say, well, but I don't want another product as well. That changed in 2018. Ever since 2018, there are 3 things that you need to know about Argentina. First of all, we now have statement of objections which regulate the way in which the divestment has to be carried out. It does provide for a very clear process in which you have to undergo so as to get the remedy. We have been seeing that when they are issuing statement of objections, as of late, they have also been ordering hold separate orders, even 6 months after closing, which is proving to be a bit challenging to start unscrambling the eggs when you just scramble them. But still, it's much better than 5 years down the road. The second one is that our Commission has been quite positive as to accept creative remedies. Of course, our commissioner would like divestments, like pretty much every other single commission in the world, because they're easier to follow and so forth. But they have cleared a lot of cases based on behavioral remedies. As of late, Natura Bon, Mirgor Brightstar. In fact, there was a very recent case, which is the Arcor ingredient case, which was a huge case in Argentina, which entailed a series of divestments and so forth. And among the behavioral divestments, there was one which was quite creative, in which the resulting entity committed itself not to hire any competitor from any employee from the competitors for the next 3 years. And that was actually accepted by the Antitrust Commission. So be creative when trying to deal with remedies before the Argentinian Commission. And the third one is that, as in the past, there did not used to be that much interaction by the Commission in the remedy process. The Commission would just say, okay, I'm okay with you transferring to this third-party purchaser, or just let me know whether you're actually complying with the behavioral remedy or not. Since 2018, we have seen that, one, we now have monitoring agents on every single case with remedies, which was quite an advance as opposed to what used to happen. And now we're also having selling agents. We were so used to negotiating the remedy, the conditions of selling the third party, to the third party purchaser on our own. And now, as of late, we now have selling agents. So there's a little bit less of freedom. We have a lot of statement of objections right now being discussed before the Commission. So hopefully by next IBRAC, we will have more news on them.
Thank you all. Based on the discussions here, it's clear that we have some common issues, and those issues are a little bit different from the issues that are being discussed in Europe and the US. But here I see that there are opportunity for collaboration between the bars and the organizations from IBRAC and the other bar associations in your jurisdictions, because as we heard yesterday from Eduardo and Alejandra, the authorities are coordinating, are exchanging knowledge, and we must do the same here because we can leverage on that. Thank you so much for accepting the invitation and for participating on it. Thank you.